Hi, everybody. Hello. Hi, I'd like to introduce our speaker today. Welcome to our second semester S.T.I.R talk. It's great to have you all here. My name is Brian Strymon, and I'm head of technical services. I've been here at the university for 30 years, and I work in the back, so you don't see me a whole lot except reference on Friday afternoons. I have known Kevin Ruser for more than 30 years, probably 40 years, and it's kind of surprising that here I am introducing him and we were roommates. Professor Ruser is currently the Director of Clinical Programs here at the University Law School. He started at the law faculty in 1985, and he also was got his career back in 1979 at the Western Nebraska Legal Services. He started in Grand Island and then finally became managing attorney at the Scottsbluff office. One of his interests is in crimmigration. It's kind of hard for me to say that. And that's kind of the melding of both criminal law and immigration law. Other things that he's involved with take him overseas to Kosovo, Serbia, Mexico, and there he works on areas of law reform and legal education reform. And I think I'm ready to go. You can check out more of his biography on our webpage. Professor Ruser, the floor is yours.
Thank you. I don't need that. I have this. So I am welcoming you to what I'm calling S.T.I.R because Professor Moberly has reordered this: imbibe, share, think, inspire, relax, right? Because now you're drinking first. Okay, that joke didn't go so well. So let me get to this, which is sort of an incendiary title, right? Why we should mostly stop teaching doctrine after the first year in law school. I want to talk to you today. First, I want a disclaimer. I don't want you to think that this is directed at any particular law school or any particular law faculty. This is a general thing on my part, or any particular law students for that matter, okay? But what's prompted me to think about this are some different things. This is a reason why we gave you the alcohol first, in case you need to be reminded about this kind of stuff, right? These are hard times for lawyers, law students, and law faculty. And one of the reasons I've been thinking about this is because of that. I think that the job market has changed, and it's changed permanently. Once the recession ends, I don't think that we're going back to business as usual, which I mean by other things that we're not going back to a sort of a universal hourly billing rate model. Right? We're going to a flat fee model because clients aren't going to pay for new associates to learn things on the job at their expense. They've gotten used to more efficiency during this recession, and they're not going to give that up once that recession ends, if it ends. I mean, hopefully it will end. And so there's also been a really robust discussion among legal educators about what we ought to be doing in law school. And that discussion actually started back in 1992 with a report called the McCrate Report, which is a report that the ABA, American Bar Association, sponsored about what they called the continuum in legal education. That is, what should law schools do before they hand law students off to the practicing bar, and then what's the bar's responsibility for educating. But the thing that I want to focus on today is what law schools, in my opinion, ought to be doing after the first year of law school. And in my opinion, we ought not to be doing what I would call more of the same, which is teaching a curriculum that's organized around doctrinal courses taught mostly, there are exceptions to this obviously, but mostly by the Socratic method. All right? When I say doctrine, that's shorthand for what I mean by that, which is organized around doctrine taught by Socratic method. And there are a number of reasons why I think we ought not to organize our second and third year curriculums that way. First, time is limited. Right? We only have 3 years with you guys. And really, after the first year, we only have 2 years, and if you're going to graduate in December, we only have a year and a half, in essence. And we have a lot of things that we need to do with you. Even if we exclusively taught doctrine to you, we could not cover the field. There's no possible way that we can teach you all the legal doctrine that there is out there. And even if we could teach you all the legal doctrine that's out there, it's going to change anyway, right? I threw away my bar review stuff after about 5 years because it was all outdated. Why? Because the legal doctrine changed for the most part. So teaching legal doctrine only, right, is not a good way to approach things, in my opinion. And that brings me to my second point about why we shouldn't do this, because we're really not teaching you legal doctrine anyway. We're really teaching you legal analysis in the context of a discussion of legal doctrine. So that's something that we could do differently in the second and third years, in my opinion. Do you all still read Pearson versus Post in first year property? The fox and who owns the fox? You don't read that anymore? Okay. Well, at least we've come a ways, because when I was in law school, we read that case even though it was from the Middle Ages, and the reason we read it was not to tell us, to have us learn what the current legal doctrine is about who owns a fox if you shoot it on one person's property and it dies on another person's property, but to help us understand how to legally analyze a case. So we're really teaching you the skill of legal analysis and application, and more specifically legal analysis of appellate court opinions. All right? We need to start doing more to have you not just think like lawyers, but actually act like lawyers in your second and third years. A third reason we ought not to do this is there are far better ways to teach legal doctrine than what we do. And if you don't understand what I'm talking about now, you will when you take the bar review course. They're very good at teaching you the legal doctrine that you need to learn in order to pass the bar review exam, or the bar exam. And so I think we're not particularly efficient at teaching legal doctrine. So that's another reason, in my opinion, that we ought to restructure the curriculum. This is the real reason that I think we ought not to do it, because there's lots of other really important stuff that you all need to learn while you're here. And I want to talk a little bit about that for a period of time. There's a guy named Jerry Hess who teaches at Gonzaga University School of Law in Spokane, Washington. Jerry Hess started something called the Institute for Law Teaching and Learning. And the purpose of the Institute, and I want to read from its mission statement, is to provide a learning environment that helps students achieve the highest academic standards and prepares students to assume their responsibilities as effective moral attorneys. So they study and write about law teaching and learning. They're a clearinghouse for ideas on how to better teach law and how to better prepare law students to enter the profession. In 2005, Jerry Hess and a colleague of his, Stephen Gerst, conducted a survey of Arizona lawyers and judges about what they thought law students needed to know in order to be effective practitioners. And I'm not just talking about traditional practice. It doesn't matter to me, and I don't think these concepts apply just to people that are going to be traditional, so-called traditional practitioners. Any kind of profession that you're going to enter, right? Whether it's mediation, whether it's business law, whether it is corporate counsel, in-house counsel, anything like that. What do those people think you need to know? Here's what their survey results said. And I'm going to talk about what they classified as essential doctrinal courses, which means that 50% or more of the respondents that they surveyed said, yeah, this is something that law students need to have. All right? So let's start with doctrinal courses. What doctrine do they think law students need to know? First is civil procedure. Right? Professor Lenich holds first place here. 87% of the respondents said that you need to know something about civil procedure. All right? That's a first-year course. You're getting that. Professional responsibility. 82% of them said you need to know something about the doctrine of professional responsibility. That's a required course. All of you have to take that before you leave here. Third, contracts. 80% of them said you need to know something about the doctrine of contract law. That's a first-year course. Evidence. 74% of them said you need to know something about the doctrine of evidence. Vicki Lill, our registrar here, tells me that 9 out of 10 of our students take evidence before they graduate from this law school. I wouldn't be surprised if that figure is similar in other law schools as well. Certainly since I've been here, it's been my experience that about 90% of you take evidence before you leave law school. Here's another one that'll make Professor Lenich smile. Remedies. See, he's got 2 out of the top 5.
Just stop here.
68%. Now, that's an interesting one to me, right? Not many people would think, and it's not a required course. It ought to be, Professor Lenich says, it ought to be a required course. Why would they think that? Well, I think it's indicative of how lawyers out in the real world doing things think. They think from the backward to the front. What is the remedy that my client is after? What do they want? And now, how do I get there? So we tend to analyze things from the front to the back in law schools, I think. I think once you get out, you're going to do it the other way. You're going to organize, you're going to analyze from the back front. And they want to know what remedies are available before they start figuring out what the civil procedure is or the contract law or how we get it into evidence. Torts, 67% of them said you need to know something about that. That's a first-year course. And property, 62%. All right? That's the sum total of the doctrine that practitioners and judges considered to be essential. 7 courses. Most of them are first-year courses. One of them is a required course, and remedies. Right? That's what they thought. 7 courses. Now, what about essential lawyering skills? What kind of lawyering skills do they think you needed to do? I'm not going to go through them in any great detail, but you can see that list is deeper. And by the way, that's only the first half of it. 15 different essential lawyering skills that people thought you needed to know. 50% or more of the respondents. All right? Look at some of this stuff. Listening. How often do we talk about and have you practice listening skills in law school? Drafting legal documents, oral communication, working cooperatively. All right? Factual investigation. How much of that do you do in law school? Right? Interesting stuff here. Pretrial discovery, ethical dilemmas, problem solving, all of that sort of stuff. Right? 50% or more of them said that you have to know that. These are essential lawyering skills. What about essential professional values, which is sort of the third leg of this 3-legged stool, right? Doctrine, skills, and values that everybody talks about. Well, that list is even deeper, 17 deep, that 50% or more thought you needed to know as essential. And look at some of this stuff. Right? Treating others with respect, diligence and work ethic, maturity, autonomy and judgment, self-motivation, self-confidence, commitment to professional growth. And pick out your favorite one here. Healthy stress management. How much practice do you get at that in law school? Right? Maybe stress management, but I don't know how healthy it is, right? Promoting justice and fairness. I mean, do we talk about that a lot in law school? And yet that's something that 73% of people said you need to know how to do. All right? So there's this long list. This is that list of important stuff that I'm talking about in slide 4. Where am I on my time? Okay, I can do it. How do you get to Carnegie Hall or become a good lawyer? You practice, practice, practice. That's how you get there. We need in the second and third years to allow you to practice, practice, practice. Not just doctrine. Right? But skills and values as well, the kinds of things that they rated as essential. We need less practice on legal analysis and more on the other areas, in my opinion. Fake out. We don't need to make this decision. I'm putting a false choice to you. We should be teaching doctrine, skills, and values. Of course we have to teach doctrine. We can't have this discussion about skills and values in a vacuum any more, in my opinion, than we ought to be talking about doctrine in a vacuum, missing skills and values, right? But in my opinion, we got to fall out of love with this idea of only teaching doctrine, of organizing our second and third year curriculum around doctrine as opposed to skills and values. Better, let's do this in context. Let's use doctrine to teach skills and values, especially in the second and third years. If nothing else, it's less boring, right? You guys get this legal analysis figured out for the most part after the first year. We need to be using our second and third years, which is precious time to do other stuff. There's a book called Best Practices for Legal Education that got published in 2007, and here's how the authors of that book think we ought to organize the curriculum. But look at the second and third years. Develop problem solving, self-efficacy, and self-reflection. Focus on factual analysis. Get rid of case books in favor of treatises and problems. Go to the source of the law. Don't try to pull it out of appellate case decisions anymore. We've done that already. Third year, develop problem solving and cultivate practical wisdom to help students become reflective. Teach multiple doctrinal subjects in integrated contexts. That's how it works in the real world. Cases don't come in labeled as torts or contracts or property. They come in as a messy set of facts, and you have to figure out what doctrinal subjects are implicated by those facts. This is going to be more work for you guys. It's going to be more work for us, but it's better for everyone, right? If we're teaching like this in law schools across the country, you don't get to sit in class surfing the net on your computers, right? Because you're going to be actively involved, and it's more work. And it's going to hurt more, because muscles hurt more when you use them to practice. But you got to do it. Here's required reading. These are 4 things that you ought to read. They're hot topics. The first is the McCrate report I talked about in '92, best practices, which I just mentioned in '07, the so-called Carnegie report in '07, and Failing Law Schools is a book that came out in 2012. All of you ought to be reading this stuff. You're responsible for your own education just as much as we are. Okay? Next up, why we ought to stop grading and why we should stop giving the bar exam. But I'm out of time, so we're going to have to stop.